And this data goes through February 1st. And you can see that even at our peak with the Omicron surge here, it was during the Delta surge that we hit our highest number of hospitalizations. Our ICU bed usage is also on the way down. And again, you can see the comparison between the Delta surge and Omicron in terms of occupied ICU beds. Now, Omicron did have a jump here. This is the total new COVID admissions to hospitals per day. And this is statewide, but we're also happy to see that this is on the downward trend, and hopefully it continues that way. This is data from last week, dated January 30th through February 5th of 2022, and Hawaii is right there in the middle. So we had the 27th lowest infection rate in the nation, and that's up from being in the 19th lowest spot in the prior week. For the duration of the pandemic, which is defined here as March 7th, 2020 through February 5th, 2022, Hawaii continues to have the second lowest infection rate in the nation, second only to Maine. And then this data from last week shows that Hawaii had the 9th lowest infection rate in the nation, up from 3rd lowest in the prior week. Hawaii's death rate did increase to 3.5 deaths per 100,000 individuals, and that was up from being at 2.1 the prior week. But the death rate is a lagging indicator, so we would expect to see that increase somewhat at this stage of the surge. And then for the entire duration of the pandemic, Hawaii continues to have the second lowest death rate in the nation, second only to Vermont. And then this slide shows the rate of confirmed COVID-19 infections and deaths per 100,000 in Hawaii over the duration of the pandemic. So Hawaii's infection rate continues to decline, and it dropped to 644 per 100,000 individuals. And that was down significantly from our peak at 2006 in mid-January. So just a couple of weeks ago. And then for comparison, you can see that at the peak of the Delta surge here, Hawaii's infection rate was 408 per 100,000 individuals. So again, just a marked difference. Okay, so Dr. Wen, with that, I'm going to hand it back to you.
I think that's just a testimony to how important the vaccine is. And so keep on encouraging those vaccines as best as you can. All right. Okay, I'm going to let Dr. Fernandez take it away.
Aloha, everyone. Good afternoon. So happy to join you all via Zoom to discuss this very important series, What Matters? And who knows what matters most? This is a lovely series. We're going to have 4 lectures over the next 4 months on this series. And this is getting to the heart of the issue. We can talk about so many things, but what is most important needs to come to the surface. And I thank Dr. Wen and the ECHO series for bringing this to our nursing homes and care homes and foster homes. So it's important to focus on what matters. And we need to decide, why are we planning for this? Why do we need to think about what matters and what's going to happen down the road? It's because we all are living longer. In the old days, people did not think they would live that long. But you could see now countries all over the world, like Hong Kong, Japan, they're leading with highest life expectancy. So as the life expectancy increases, we need to plan for our future. I'm looking at how to advance. These slides are jumping for me. Okay, let's look at the term capacity. Capacity is typically all of us are considered to have capacity. You are considered to have capacity. I am considered to have capacity. And an individual usually has decisional making capacity when they are able to receive, understand, evaluate information, and communicate a particular choice. So let's take a simple example. Do you want chocolate ice cream or vanilla ice cream? Can a person communicate that choice? Do they know what ice cream is? So, it doesn't have to be so complicated, but in medical healthcare, we have seen, do you want dialysis? Do you want chemotherapy? Do people understand what their medical information? Can they make that choice and communicate that choice? I'm looking at how to advance these slides. Okay, we're on to the next slide.
All right. No, just say next slide and John will move it for you.
Oh, I was hoping to be co-host so I could move.
Okay.
When we are talking about capacity, it is very important to understand capacity for what. Everybody may have capacity for something, but as they get older, they may lack capacity for something else. For example, they may be able to drive, but they may not be able to handle their checkbook. Or they may be able to cook, but they cannot handle their pill box or their medications. So when we are talking about capacity, especially decision-making capacity, physicians and the healthcare need to narrow it down, because we cannot just say, oh, he or she has dementia and they can't do anything. That is not the best practices today in dementia care. And we need to really narrow it down. What do they have capacity for? Maybe they can do X, but they cannot do Y. Next slide, please. So who gets to decide this? We often hear these terms, capacity, competency, and these are very confusing terms. Capacity is used typically in the medical setting, and competency is used in the legal setting. So typically a doctor will say, or a provider, a nurse practitioner will say, person has capacity or lacks capacity. But competency is determined by the courts. Now, most everyday issues are determined without medical or court intervention, right? It's common sense. Can they drive? The family will say, no, Dad, you cannot drive anymore. So a lot of things are determined without doctor intervention and lawyer intervention and court intervention. Next slide, please. So decision-making capacity, if you are looking down that road, can this person really make a choice? Can this person decide? And say you are the nurse at a nursing home or a care home operator or foster home operator, who do you turn to, especially if you feel my patient, I think, lacks capacity? Then you need to go to the medical doctors. And there are different specialties that deal with this. It could be a geriatrician, a neurologist, a psychiatrist, maybe their primary care doctor, the PCP. They can all determine decision-making capacity. However, if you are talking about competency, then we got to go to the court. It is the judges who make that decision, because they decide if person has legal capacity, and they may decide if person needs guardianship, conservatorship, and protective services. Next slide, please. So who needs a guardian or a conservator? I know some of you have patients who have a public guardian appointed, and every time you need consent or permission, you have to call up the office of the public guardian. So how is this determined? Who needs a guardian or conservator? It is for that person who is unable to receive and evaluate information or make or communicate decisions to such an extent that the individual lacks the ability to meet essential requirements for physical health, safety, or self-care, even with appropriate and reasonable available technological assistance. So this is a loaded sentence, right? It's not so easy, and it takes time and it takes a process, and one has to petition with the family or probate court. Now we have an expert here. I'm so honored that Professor Jim Peach is here today. He's a professor at the law school at UH and has served on the polls. Professor Peach was behind that whole movement in getting the act passed, and I'm so honored he's here. Professor Peach, would you like to add something about who needs a guardian or conservator?
Sure, and it's wonderful that the medical and legal professions are coming closer and closer with each other with respect to these issues and even terminology, because the legal profession has been needed to move and is moving closer to the medical profession in the use of the terminology capacity and incapacity. And we have mutual clients and patients, and we can benefit from each other's expertise and also assistance. For a guardianship or conservatorship, this is the threshold that you see in the statute itself. And it's important to note that this is not necessary if there are suitable and available alternatives in addition to technological assistance that's in the statute. But the alternatives are what the judge will be looking at to see, is there anything in place already, such as powers of attorney? Two types of power of attorney, of course, are the healthcare power of attorney, which in your patients' lives is probably the most important thing that you need to check for. In our world and in your world too, we also have the other type of power of attorney, the legal and financial power of attorney. Two separate documents. Sometimes they're very often confused, but if you have both of those and they're properly crafted, that can help very much with avoiding guardianship or conservatorship. And then on the financial side, especially, we'll see the use of living trusts to manage property, which the living trust used to be primarily a mechanism to avoid probate, but now it's almost more used to avoid guardianship and conservatorship and to manage property of individuals who are no longer mentally capacitated. So with those types of documents, you can avoid guardianship and conservatorship even for those who are unable to meet the threshold here. The person could be in a coma in a persistent vegetative state and not require guardianship or conservatorship if they have these alternatives in place. So I think it's important to note the alternatives. And as Rita Bell mentioned ahead of time in the previous slide, she showed some of these documents. Each one of those documents requires a different level of capacity. Ordinarily, our profession, the legal profession, can make an assessment as to a client's capacity. So if you have just the typical client coming in and wanting to make a healthcare power of attorney, a regular power of attorney, and a trust in order to avoid probate, and then add on to that the will, perhaps something of that nature, we can make that assessment if the individual has the ability to understand the significance of those documents, because the thresholds for those documents for capacity are different. One example is the will. Under the law, the will has the least requirement for capacity level than any of those documents. So it makes some sense, because if you want to give somebody something, it's a natural thing, but setting up a complicated trust may involve more capacity. So again, the medical legal professions coming closer together. We use your assistance when necessary. When we can't make that determination, we ask your help in making that determination of capacity.
Thank you, Professor Peach, and thank you for always partnering with us. We appreciate the medical legal partnership. Next slide, please. So let's look into what is guardianship. It is looking at the person. It is giving an individual an authority on matters relating to the physical and mental well-being of a person, and that person is known as the ward. And the duties involve deciding where they will live, their clothing, their furniture, their vehicle, consenting to medical care, providing care and comfort. And many of you at nursing homes and care homes have often dealt with guardians and the OPGs. So you know that you need to get consent from them and give them a call. Let's look at the next slide. What is a conservatorship? It grants one or more people the power to make estate planning decision on financial matters for someone who is found unable to manage their affairs. So it is typically the property or the protected person. So buying food, managing property, acquiring and managing assets, paying bills. So it is all related to financial and money issues is when we seek conservatorship. Next slide, please. So what are the downsides to guardianship and conservatorship? It's a slow process. It's not fast. One has to go to the court, make a petition. It all takes time. There's legal fees. So I have to make a plug. We always have wonderful UHelp program at UH that can help people. We have a legal aid that's available, but still it takes time and money. And there are some downsides to this. There is loss of autonomy. I mean, who would want a guardian appointed? I would want to remain my own boss. I don't want someone to be my guardian. So you don't want to lose their autonomy. So what are the other options? And Professor Beach mentioned some of these options, and I would like to go cover them slowly. So let's look at the next slide. What are the alternatives to guardianship and conservatorship? Simple documents, simple, easy documents like the healthcare power of attorney. Let me make that. That's simple. Financial legal power of attorney. You can establish a power of attorney to handle your banking and other general issues. A rep payee, representative payee, often Social Security, they have a form for this. A rep payee can be assigned so that people's Social Security monies can then be used wisely and budgeted to last the full month. There are companies that offer money management, and there's always the trust. So let's look at each of these. Next slide, please. Power of attorney. One needs to remember to choose wisely. You want either a family member, a trusted friend, maybe a lawyer. When you're choosing your power of attorney, you can give them full legal powers, or you could give them limited powers. So an example of a limited power is, say I'm buying a real estate and I'm going out of town. Maybe I want them to sign all my escrow documents. So you could limit it just for that real estate transaction, or it could be broad and cover all general transactions. It can take effect immediately or upon incapacity. Now, what about revocation? You can have a written revocation, or you could execute a new power of attorney. So you're not stuck with this document. Next slide, please. This is just showing you the form and our act in Hawaii. We cover all of these. The law protects you. You can have general, limited power of attorney, durable, non-durable. You can decide when that terminates and when it's effective, and any special instructions you want to give. Next slide, please. So the Uniform Power of Attorney Act, it ensures that the power of attorney will be accepted by banks, financial institutions. It ensures that the power of attorney is valid, validity executed outside of the state will remain valid in Hawaii. And it ensures that the agent is liable for violations in terms of power of attorney or the Uniform Power of Attorney Act. So there are legal protections in the laws and in the acts of our state that gives the power. At the same time, it also can hold them liable for violations. Next slide, please. Money management. You can set up simple things like automatic bill payment. Such a simple thing where people's electric bill can be paid. Social Security strongly encourages beneficiaries to receive their benefits through direct deposit rather than mailing or a check, because you don't want fraud and check fraud, mail fraud. So there are simple money management strategies that can be done to help seniors. Next slide, please. There's also the Rep Pay, where you can appoint somebody to manage benefits, such as Social Security benefits. Even the VA has a program called the Department of the VA Fiduciary Program, and it requires medical documentation, or that person cannot manage their financial affairs. But once that is set up, it makes it so much easier to ensure that a person's bills are being paid and they are not falling into debt and getting late fees and fines. Next slide, please. And the final instrument, the grand best instrument, is the trust, especially if you have a lot of property, a lot of assets, to consider a trust. In a trust, there is the trustee. Typically, it's often the person themselves. They make a living trust, so they manage their trust while they're alive. And assets can only be used as instructed while in the trust. So important thing to understand is you can make a trust, but you have to put the stuff in the trust. You have to change the deed of your property to put it in the trust. You have to change the bank account, put it in the trust. And often people forget this step. They make a trust, but they forget to put things inside the trust. But there's the trust, a trustee, and beneficiaries. Next slide, please. So the commonest trust that you see here in Hawaii, which majority of people make when they say I have a trust, they make a living trust. And they typically make a revocable living trust, which they can change during their lifetime. Special needs trust is different, often may be used for persons with disability, parents with a child with disability. They may set up a special needs trust, and there are other kinds of trusts. But the commonest one is the living trust, revocable living trust. Sometimes people say, oh, I have a living will. What they mean is they have created a trust, and often that terminology, they may say living will. That is the advance directive that's in the trust and created when they have made that trust. Next slide, please. Professor Peach has given us this wonderful resource called the Deciding What to Do and Why Not Now. And these books are available through UHelp and available through HAH. And you can contact Michaela for copies, as well as UHelp for copies. It is like a Bible and will guide you through these 4-part series. So look at the chat. Dr. Wen has put the link. You can get an electronic copy as well of this wonderful, wonderful resource. Next slide, please. So look at the chart. If you say, Dr. Fernandez, where am I going to find all these things? Look at the chart. There is the general power of attorney, maybe there, the green form, the post, maybe the advance directive. They're probably in the chart. So take a look at the patient's chart and see what's there and what's missing. Next slide, please. So you're looking for 3 things: the general power of attorney, the advanced healthcare directive, and look if they have a post. Next slide, please.
Michaela. Oh,
Sorry, I was able to unmute.
okay.
So after our evaluations today, you're going to be getting an email asking for a little bit of help collecting some of this information. So you're going to get an email with an additional link. Sorry, John, can you back it up one? Yep, you're going to be getting an email with an additional link asking for more information. We want to know how many of your residents have a power of attorney, how many have an advanced care planning form, and how many have a post form. This information is going to be kept confidential. We will de-identify it, so we're not going to be sharing the name of your organization with anybody on this. This is a chance for you to assess where your residents are and where your organization is at. And it also is really helpful to us. We are grant funded, and this kind of metrics help us continue to get funding, showing that there's some sort of change. So we're going to do a pre-survey this month, and at the end of our series in May, we're going to do a post survey and ask for this information again. So this will be sent to you in an email after you complete your evaluation. If you have any questions or any concerns, you can join me in Zoom. I'm going to have times available on Friday and Monday to meet with you. Or if you want to just email with me or set up a private time to meet, you can email me as well. I can put my email address in the chat box for you right now. And I'm also going to be including a link that Gail gave us with different forms that may be helpful. So this is the Stanford forms, and I'm going to email this here as well if you want to meet with me.
So Jacqueline Mock is asking a question. When a POA states agent authority upon, starts upon person's incapacity, but person still has capacity yet wants to defer it to an agent, can the agent make the decisions? And maybe one of the panel guests can answer that question.
Well, there are two areas in, for example, the Advanced Healthcare Directive, the durable power of attorney for healthcare. One is when it becomes effective, and either immediately or upon incapacity. And then there's another section, well, it's within that section that the individual can grant the authority for the power of attorney for healthcare to allow the agent to make healthcare decisions immediately. So you have to take a look at the words. Some individuals will say, yes, my agent can make healthcare decisions immediately. So take a look at that. And then for other individuals, they may be silent on when the agent's authority can take effect, except to say, for example, they could say takes effect immediately, takes effect upon incapacity. The default under Hawaii law is if nothing is said, then the healthcare power of attorney only takes effect upon incapacity. So you have to look for that block, see if it's checked off. It's the opposite of the legal and financial power of attorney, where the default since 2014 is that the power of attorney is effective immediately unless otherwise stated. So we don't have too much time today, so read the book. It's in there.
All right, there's two more questions
We
over
decided
here.
to put plain English.
Great. We have another question from Jacqueline and then Dan Saltman. We'll do those, and then we're going to move on to a couple more slides.
All right, so Jacqueline says authority can be granted verbally, or does it have to be in writing?
What authority?
I believe on the question that she posed that you
I'm
just
sorry,
asked.
maybe I can say.
Oh, okay,
Yeah,
Can
please.
everybody hear me okay? Okay, I don't type that fast. Mr. Peach, I think
Mhm.
earlier you said, or maybe I should confirm this, maybe I misheard you. So my original question was, if the power of attorney states clearly that the agent will not have authority until the person is determined incapacitated.
Right.
But yet, there's a lot of parent-child relationship where the parent just want to defer. So, oh, you just talk to my daughter. And so my question is, can the daughter then make the decision for mom? And if I heard you correctly, I think you said if the person grant authority to the daughter, yes. So my second question is, does that authority have to be granted? Can it be verbally, or does it have to be in writing?
Well, again, if it's the Advanced Healthcare Directive, you have two separate areas of discussions, privacy issues under HIPAA, for example. So you can have the daughter sit in with those conversations. But if I were the healthcare provider and there's a serious decision to be made, and under what authority are you making that decision as the agent, somebody's going to question that that power of attorney doesn't really say they have the authority until the individual becomes mentally incapacitated. So an easy way of fixing that is if he or she really wants the child to have that authority, is to simply make a new advanced healthcare directive with the authority that's effective immediately. That would make it very clear. The only you can't grant authority to an individual orally. The only time that oral declarations of who you would want to have as a decision maker would be when you're looking at surrogates, but that doesn't involve the healthcare power of attorney. So yes, you can still have the child involved in conversations, but as long as the person has made it clear in the power of attorney that the decision making itself does not go into effect until incapacity, then the safest thing would be to say that, well, could we ask you to change that document so that in our files, when we're making decisions for an amputation, for example, you're going to be covered. So that's part of it too, because under the law, you're provided certain immunities from civil and criminal liability for in good faith following the directions of a person with apparent authority. The authority in the case of the Advanced Healthcare Directive is in that document.
What if you don't have time to execute a new advance directive and decision has to be made? Would it be acceptable if you pull in this example, the mother and the daughter together, so you don't have an HIPAA problem because the mother is willingly to have this conversation in front of the daughter, and they make the decision.
That's quite common, where for one reason or another, they don't mark the block that it goes into effect immediately, or they don't say that. But you can still have that conversation because the mother is still competent. She can revoke, as Rita Bell mentioned, you can revoke that one and have another one. But you can say, well, work with me here. We'll have your daughter in there. Would you like your daughter to engage in the conversation? Yes, I just told you that. Well, then you and your daughter can stay here and you can talk with your daughter. Okay, are you agreed with your daughter's decision? Then that's her decision too. That would seem to work.
And the next question, or the last question for you, is if someone wanted to establish a trust and had simple assets, would they be able to do that without a lawyer?
Yeah, well, it's like my brother-in-law is a dentist, and he said there's nothing illegal about you drilling your own teeth. So sure, have at it. It may not work, but there's no law that says you have to have a lawyer. But we've seen so many just downloaded documents from the internet, and nobody knows what it means, and it's a complete mess. And many times it was, well, if I was told that if I made a trust that I would qualify for Medicaid. Well, you just did the opposite. And now you're disqualified because of what you said in that trust, especially about your house, and you transferred it in there. But it's up to the person to determine what the risk is. You're balancing, should I pay a lawyer to look at it, or do I have enough knowledge? Many people have enough knowledge to do that, but that's the risk that they take. Again, when when I go to Africa, I'm going to call Johnny Yates and say, what do I need to do to go there? And he's going to give me information. I say, I don't want that. Well, you'll be stopped at the border, he'll tell me. So we have different professions, different skills. And so we hear that all the time. Why do I need to pay a lawyer? Well, up to you.
Okay, thank you. All right, well, let's move on to the next part, and then we'll have time, if we have time for questions later, we'll continue. Go ahead.
Sounds good. Hi, can you hear me all right?
Yeah.
All right. Seeing what the subject matter was today, I decided from a QI perspective that I would take the concept of what matters most and see what IHI, the Institute for Healthcare Improvement, has to say about it. So it led me down an interesting trail, and I probably know about as much as is on these slides, but I think it opens up some good things to think about. Next slide, please. So what I found was there's actually officially what matters to you concept. Maybe you guys have discussed it in medical training, but it was first shared about 10 years ago in the New England Journal of Medicine as a method to implement shared decision-making. It's when really patient-centered and person-centered care, I believe, started to come into sharper focus. From what I gather, it was intended really, or if its use was focused on primary care and acute care, not so much in transitional or long-term care, but I did find a study out there looking at the use of this tool in long-term care. Now, I'm not necessarily advocating for sorry, that was my dog going up the stairs, advocating for the tool itself, but really the concepts that lie behind it. So the tool, I think, especially for our use in long-term care, is really about compassion and empathy, listening to your patients and your residents, discussing, what matters to them as you're developing their plan of care. It was intended really to help providers set goals for residents, but I feel like it's a brilliant question for other caregivers to get to know and understand your residents. Next slide, please. So person-centered care focuses on a meaningful life and how people are recognized as unique individuals and not necessarily as patients. I had never really, I guess, put much thought into the difference between patient-centered care and person-centered care, and the use of person-centered care really in our environment is giving, I think, a different type of humanity back to our residents. Not that we don't treat them as humans when they're in the acute care, but they're really there episodically, and they're there specifically for that clinical intervention and not necessarily to be living in their home while also receiving care and services at the same time. So what matters to you really turns around the question, what's wrong with you? Or, what brings you here today? What can I do for you? To encourage caregiver resident conversations to really be focused on the resident. We want to understand what their motivations are and really what their hopes for the future are, especially if they're there on our long-term side and they're going to be living with us for a while. Next slide. So really this applies to everyone, and it never hurts, I think, to get a reminder that they and their loved ones, they want to feel included, respected, heard, clearly communicated with. They want to, and we're required to let them have a say in their care plan, and they want to feel some sense of control. I feel like this kind of hits me in my feels a lot more than some of the others sometimes when I struggle with behavior, especially when I was there in the homes or the CNAs and nurses were really struggling with behaviors. It really clearly to me always came back to a loss of control. And how would you feel if you were losing all this autonomy and all this control over the say in your life? And I think to me, that's really foundational to the rest. Next slide. So this, I'm not going to go through this whole slide, but and the sources there in the slides that you'll get, but just top tips for a what matters to you conversation. The points are, that's a question that could be for everyone. You really want to approach them with curiosity and the intent to get to know what matters to them and what makes them tick. use your open-ended questions, be authentic, provide active listening and practicing of empathy. Show your listening. It's all your basic good listening and conversation skills. Next slide. So I put might be a heavier question for providers to ask in the context of a resident's medical plan, only because from what I was gathering in the research is providers, I think approach it, or it was presented to them in some of these studies as really a way to create a care plan, clinical interventions, and to provide them with the clinical care that they need. And providers sometimes would have a fear of approaching it in this way because of concerns over unrealistic expectations, concerns over what do I do if what is important to them is not something that I can provide in a clinical sense. So I only just point that out, but I still believe that in our context, it's something our providers are also functioning within the context of making them comfortable and at home. And I don't feel that this tool would, I guess, scare off our providers, for lack of a better word. Also, that care transitions and coordination across the continuum are tricky, and there are concerns that you may end up having conflicting goals, moving from acute to transitional to long-term care, and who's going to be responsible for addressing that once they're landing with us, addressing maybe those misunderstandings about goals, or goals that weren't addressed maybe prior, or the residents come with a specific expectation that maybe we can't provide. Next slide, please. I mentioned this in those top tips. We all need to have or develop our skills around communication, listening, empathy, and reflection. And I think that's ongoing skill development for all of us, critical not only in our profession, but in life. And then we've got to be able to elicit resident goals sensitively, and have the conversations with residents that we need to have in order to make sure that we've got realistic and achievable goals. Now, in the context of how a resident wants to live their life in the home, I think we have a lot more say, I think, in ability as non-physician caregivers to elicit and address those goals as to how they want to live their life, how they want to be treated, who they want to see. Next slide, please. So I know we're getting short on time, but I wanted to ask the question, if we have time, if anybody is interested in sharing, if you've used any unique tools to get to know your residents and what matters most to them, either on a admission or ongoing, because when we take time to build the relationships, we're providing them with a much more meaningful life, a more meaningful relationship with us, and that should affect and benefit both residents and caregivers, and could provide you a reasonable metric for your QAPI plan if you're monitoring resident satisfaction, for example. So I'm curious if anybody's got, we're going to talk about this more in depth next month. So if somebody's got something they'd like to share quick now, we'll take it, but otherwise be noodling on that. And I'd be really interested to see and share the types of practices folks are using to get to know their residents as people outside of their needs and what matters most to them. And I think the next slide is just my references. So does anybody have a unique tool?
Well, I'm not in the position that you're asking for that, but in our book, if you look on page 192, and as I gleefully say that the healthcare and the legal professions are getting closer and closer, we have a document that says on top, what matters to me. So throughout the book, we do that. So we're getting closer and closer. We want our patients and our clients to tell us what is important. And so these documents tend to be, boilerplate, this and that, but we're encouraging the newer attorneys to put in these documents, what is important to me? I'm signing this document. I want to stay in my own home. I don't want you to sell the house from under me. Those type of things. Same thing in the advanced healthcare directives. What's important to me? Kokua Mau has a great program also on what's important to me. I want to be able to walk with my dog on the beach or something of that nature. So I think it's really very, and I just had to interrupt because I think it's marvelous that we're thinking so much alike
Yeah.
with our mutual clients and patients. So I think it's wonderful.
Oh, thank you so much.
I did have to mention one thing about when you're doing that survey about advanced directives and powers of attorney and POLS, you should realize, of course, that federal and state law prohibit healthcare providers from requiring these documents. So just keep that in mind too, when you're asking about them, you can't require them. Even though it would be very helpful to you, of course, but they're both federal and state laws that prohibit you from requiring that as a condition for receiving healthcare.
Okay, with that, we'll segue into Gail, and it'll work perfectly.
Yes. So when I did a little research on what matters most, I learned that there was some letters that were for, say, your residents that speak a different language, for them to tell you what matters most. And the letter says, you know, what do they want at the end of the life? What matters to them? Like, do they want to be at home? Do they like gardening? And then some important future milestones. So there's a letter for the doctor, for a resident to ask, or yourself. And then I went further into looking online and found the Stanford templates that ask us to review our life as, you know, say, for example, we know we're
Next
going
slide.
to pass away. So what happens is we prepare for it because we get a diagnosis that's going to be terminal. But what about us preparing for something that we're not sure is going to happen when we step out the door and go to work tomorrow? And maybe we get in an accident and we don't go home. So on that, they have a section there that you can review your own life tasks, such as acknowledging people, remembering them, key moments, asking forgiveness, forgiving others, saying thank you, saying I love you, and then saying goodbye. And putting it in a letter form and having it ready for a time when something happens, if you haven't gone through all these advanced directives and created all of those for yourself. You know, you can kind of review what matters most to you, so that your family members know, you know, what it is that you want them to do for you. And I know that legally you can set up all of your life trusts, living wills, and all of this. But this is like a personal letter. So you can find that on the templates, the letter project from Stanford Medicine, and it was put in the chat box. And I really didn't want to go over my time. And I know that there were a few more questions that had come in.
Great. You know, I just wanted to also just mention that if you want links for the forms for the power of attorney for healthcare, advanced directives, and POLS, they can be found on Kokua Mau. I think we will also post that on our ECHO website as well, where you registered in the first place. We're going to post those there so you can find those legal forms specific to Hawaii with regards to the healthcare power of attorney and the POLS forms.
Oh, that worked out.
That's
good.
what was the question that was asked, I think.
Yes, about the forms. So hopefully we've answered your questions. And if you do have any more questions, we can also, you know, take it in the chat box and then bring it up on the next ECHO program. Right?
Yes.
Yes.
All right. Any last minute comments?
About Kokuamau, they're wonderful people. We work closely with them. So you'll see that our forms are similar in character because we work closely together. So we have the forms on our website too, when you go look at the handbook, except that they have the pulse forms on their site and we do not.
Yeah. We will go into more depth with how to have these conversations and some challenges with the conversations and also how to fill out these forms and things like that in our coming sessions. So hang tight. We're going to get there.
I placed the evaluation link in the chat box. Please do take our evaluations. They're required for CME purposes, but they help us with our planning. When you're done, you'll get that additional link for our data collection.
Thank you, everybody.
Thank you.
Thank you. And
everyone.
I'd like to thank Michaela for picking up all those books. So please take them away from her in case they're still in the back of her van there. So, but she was very kind to come over and pick them up.
Yes, please let me know if you want some. I placed my email. I'll put it again. Yes, and Dr. Fernandez put in the website.
Perfect. All right. Thanks, everybody.
Bye-bye. Thanks for inviting me.
Oh, thank you for joining us. Thank you,
Bye-bye.
Isabel.
Thanks, Isabel.
Hello.
Bye-bye.
Yeah, thank you, Laurie.
Good
Thank
seeing
you.
you. Bye.
See ya.